right? So we'll go ahead and start. I'm Mike Smith. I'm an ER doc at Oxnard in New Orleans. Jeff Baker, who used to be at Oxnard in New Orleans, is now in Kentucky, Louisville.
University of Louisville.
And Denise Dickerson is on the good guy's side. She's a defense attorney. Marilena was a NICU nurse and then was a defense attorney and then joined the dark side and is a plaintiff's attorney. So we'll talk about why we do this. I've been trying for 22 years to be financially conflicted. It's not because I'm a good person. I've tried. If you've got shady deals, I'm down for it. Why do we do this? You're likely to be sued during your career. I give the example of what I had early in my career, probably 18 or so years ago. I was sued for not refilling a patient's Percocet prescription. It was dismissed. She appealed. And then when that was eventually dismissed, she made a complaint against my medical license with the state board. So this was 2.5 to 3 years of my life over something frivolous. Now, this is not something like where you're sitting and sweating like when you walk out of the patient's room, and that didn't go so well, right? So it's not that kind of case, but it had an impact on my life, and it has an impact when physicians get sued. We obviously have an obligation to screen for medical emergencies. With that, doesn't come like added protection against malpractice claims. So there's not like a higher standard to bring a suit. So really in Louisiana, you need $100 and a stamp to bring a suit against a physician. The other thing is I went looking for advice from the docs at my hospital, and there's lots of advice, but not a lot of experience or a lot of solid information to back up that advice. So how do we do this? So we take a physician volunteer and we give them a real de-identified case that was won by the defendant. So we have that physician prepare with their defense attorney, and then we put them on stage here today, and they're grilled by an actual plaintiff's attorney. This is what the deposition would look like in real life. So you don't want to get this. And you don't want to make that face. This other doc is also named Jeff, but it's not that Jeff, okay? Just to be clear. And you get into this after you get that letter. Dr. Baker wanted me to remind you that he objects to this cheap whiskey. Being in Kentucky. And we already talked about this part. So what do we need from you for this process? It's very, very easy to have the Wheel of Fortune effect, right? So you stare at Dr. Baker answering a question, and you say, like, why would he say that? Or I wouldn't say that. But you're not in the hot seat, and you don't have Pat Sajak staring at you like to solve the puzzle, right? Or like the Jeopardy effect. You don't have the same person staring at you. But we'll allow plenty of time for this, for questions. And then what I have always wanted for this is just for you to experience this a little bit and then open it up to ask questions of actual attorneys about what happens during a med mal case. Okay, so we're going to go right into it.
Okay, let's swear you in. Doctor, will you raise your right hand? Do you swear to tell the truth, the whole truth, and nothing but the truth?
Yes.
All right. Hi, Dr. Baker. My name is Marilena DeSilvio. Together with my partner, Jake Kelly, we represent the family of Peter Tiller and Mr. Tiller himself in this lawsuit that has been brought against you and others. Have you had your deposition taken before?
Yes.
Okay, I'm sure you've been well prepared by your attorney, but I'm going to go over some ground rules just to make our communication as effective as possible. First, if I ask a question, only answer if you understand. If you do not understand my question, if I misuse a medical term, please let me know and I'll rephrase or restate the question as often as necessary until you understand and only then answer, okay?
Okay.
I will be relying on the answers that you give today for the purposes of our November trial in Lucas County, Ohio. Are you aware of that trial date?
Yes.
Therefore, if at any point in time you need to go back to modify an answer, edit it, do whatever it is you need to do to make it its most accurate under oath, please let me know and we will accommodate you, okay?
Okay.
Terrific. What, sir, have you reviewed to prepare yourself for your testimony here today?
I reviewed the medical record.
Okay, we will mark as Exhibit 1 the medical record of Peter Tiller. Sir, can you tell me how many pages is the medical record that you have reviewed?
Front and back.
Yes, sir.
Looks to be about 8 pages.
When was the last time you had the opportunity to review that document?
Would have been about a week ago.
How much time have you spent readying yourself for today, reviewing the medical record?
I don't recall. Probably about around an hour or so.
Right. How much time did you spend with the patient?
I don't recall the specific encounter on that day. So just looking at the medical record, it would have been over a couple of hours, but I would have to time it up, total it up.
Is your testimony here today, sir, that you were at the patient's bedside for over a couple of hours?
Of course not.
Okay. How long were you with the patient at the patient's bedside?
I don't recall that.
Were you there an hour?
Probably not.
Fair to state then you've spent more time reviewing the records to prepare yourself for your deposition than you did actually physically caring for Mr. Tiller.
That would be accurate.
All right. Let's see if we can agree to some things. Do you agree that chest pain that is more likely associated with ischemia is substernal or sternal in nature?
It can be, but not always.
More likely than not, would you agree that it is sternal or substernal?
Not certain how to answer that question.
Okay, fair. That's a really fair edit, and I appreciate you not answering the question. So in our jurisdiction, more likely is greater than 50%, 50.00001. Just a little piece of paper to tip that scale. More likely than not, greater than 50%, would you agree that chest pain associated with ischemia, more likely, not always, is going to be sternal or substernal?
I don't think I can agree with that.
All right, so you would disagree?
Yes.
Okay. And if the literature would bear you wrong, or if the literature would support my proposition, I take it you would disagree with the literature.
I would have to review the literature before I could make a determination of that.
Are you a member of SAEM?
Yes.
Why are you a member?
It's an amazing organization.
And would you agree that its publications and guidelines set the standard of care?
It is one of many organizations that help do that.
And you would agree that SAEM teaches its physicians to act as reasonable and prudent physicians would?
Yes.
Okay. With respect to Mr. Tiller, can we rely on the medical records in this case as being an accurate depiction of the pertinent aspects of his emergency room care?
My medical record, yes. I can't attest to the rest of the medical record.
Okay, you've had an opportunity to review it. Is there anything that you see in the chart that is inaccurate or incorrect?
I would have to review it more extensively before I could answer that question.
Okay. What time did Mr. Tiller arrive to the emergency department?
It appears that his EKG was done at 7:22 a.m.
If you'd look at the front sheet, it has visit information. Can you tell us the date and the time that he arrived to the emergency department?
It is documented as January 25th, 2023 at 2:03 p.m.
2:03 p.m. Okay. What time were his troponins drawn?
According to the medical record, and that's the only thing I can go by, looks like they were probably drawn at 7:50 a.m.
So the troponins, according to the record, were drawn before he even arrived to the emergency department. True?
It would appear so in this medical record, yes.
And you don't have any knowledge about Mr. Tiller outside the medical record, correct?
Correct.
All right. At least according to the troponins, they are documented levels for a patient who had not yet even presented to the hospital. True?
according to the medical record.
Can you please read for me the EKG interpretation for Mr. Tiller?
My EKG interpretation is normal sinus rhythm, left axis deviation, and non-specific T wave changes.
Could you read for me the official interpretation on the actual EKG strip?
I was not provided with that EKG.
The EKGs that were purportedly done for Mr. Tiller are not included in the medical record, true?
I was not provided with them, correct?
And you don't have them in the 8 pages that you reviewed for about an hour a week ago?
Correct. No one gave me those records.
Okay. Do you know that they exist and were not given to you?
I have no knowledge of that.
Did you ask to see the medical records?
Yes,
Were you provided any in return?
only this.
Can we conclude then, based on what you have before you, that Mr. Tiller has documented in his chart that 2 EKGs were done, but neither EKG strip is included in the record?
There are 2 EKGs documented as being done, but again, I was not provided any EKGs to review.
And none are included in the record, correct?
Yeah.
All right. And there are troponin levels that were done, but were done before he even arrived to the emergency department, true?
According to the medical record.
And you don't have any information to the contrary, correct?
Just based on experience that it would be impossible to draw blood on a patient that's not physically present.
True. It would be physically impossible, correct?
Correct.
Right. And there are mistakes that are made when patient labs are drawn, true?
I would say that could happen, yes.
Okay. And you don't have any evidence in this case to tell me a mistake wasn't made, do you?
Nope.
All right. What was Mr. Tiller's chief complaint?
I believe,
According to the reason for the visit by the triage nurse.
as stated by the medical record, chest pain, actually, I'm sorry, chest symptoms, complaints, nausea, vomiting, shortness of breath.
And under the comment, what does it say?
Started last night, went to work, got worse, pain mid-sternal, rating to jaw and neck.
Okay. Do you believe that complaint of pain to be pain that is likely associated with ischemia?
Not enough information to tell that.
Right? What additional information would you need in order to determine the etiology of that pain?
Well, I would do a history and physical exam myself, not just read the medical record or rely on the triage nurse. And I would conduct a objective assessment, EKGs, chest x-rays, and blood work.
And upon conclusion of everything you've just described, would you arrive at a differential diagnosis?
Yes, I would have a working differential diagnosis early on. So, but after the evaluation, my differential diagnosis would be modified.
And did you have, we'll strike that, you don't have a memory of Mr. Tiller, true?
I do not have a specific memory of this patient.
So what you're going to tell us today about your interaction with Mr. Tiller is based upon the 8 pages of record and your custom routine and practice, fair?
That would be fair to say.
Okay. There's an ED note by Donna Asep, RN. It states, upon arrival denies pain. Do you see that?
Yes.
Had Mr. Tiller received any nitroglycerin on the squad?
It's not documented there, but I recall that he received it prior to coming to the hospital.
Do you agree that chest pain that is more likely ischemic in nature is more likely to be relieved by nitro or rest?
Not necessarily.
When can it be?
It could be ischemia. It could be other causes of pain, GI-related causes. It could be incidental to his actual pain.
Is it your testimony under oath today that nitroglycerin more likely will relieve chest pain that is GI in etiology?
I don't think anyone can make that determination.
Do you agree that nitroglycerin is used to relieve chest pain that is ischemic in etiology?
It can be, yes.
All right. And that's what was given to Mr. Tiller, correct?
According to the medical record, yes.
And his chest pain improved as one would anticipate, true?
That's what is documented in the medical record.
Okay. And then Donna says that Mr. Tiller complained of shortness of breath and rapid respirations. Do you see that?
Yes.
That he was had eyes fluttering, tremors at times, was encouraged to answer questions, not following directions, and slow speech. Do you see that?
I do see that documented, yes.
Is there anything about Donna's note that is of particular moment or interest or significance to you as you learn about and are introduced to Mr. Tiller?
I don't quite understand your question.
That's fair. Is there anything about Donna's note that you would like to emphasize or highlight as it relates to your care and treatment of Mr. Tiller?
Not particularly, no. So,
Okay. Did Mr. Tiller, let me back up. What are the risk factors for coronary artery disease?
there can be numerous risk factors, strong family history, smoking, hypertension, diabetes, high cholesterol, and other factors.
How about age?
Age can be, yes.
What age can be?
It's going to vary a little bit depending on the source. I would have to review specific source. You start thinking about it, we'll say age 55.
Was age a risk factor for Mr. Tiller?
I believe he was 60.
Is that yes?
So, yes.
Any other risk factors that he had that you're aware of?
Not that I'm aware of.
All right. Can you walk us through, please, once you learn about Mr. Tiller? Well, first, how do you learn about Mr. Tiller? How do you know that you have a patient in the emergency department?
Not certain I follow that question.
Does a nurse alert you? Does the computer alert you? How are you told to come on in and see a patient?
At my emergency department, the patient is registered, placed on a board. So electronic health record, I see the patient on the electronic health record. I place my name on the patient. I go see the patient.
All right. Do you document contemporaneous with your visit with the patient after you're done, or a combination of both?
A combination, not always in a combination of both. It's very situational.
Okay. Do you have a standing or moving computer that you utilize in your emergency department?
No.
Okay. Where are your computers maintained for documentation purposes?
They are in a central area in the emergency department.
And how do you keep notes, if at all, that you later enter into that computer?
I do not keep any notes.
Okay. And what time did you dictate your note?
According to this, I actually don't see a time. It looks like it was signed at 2:39 p.m.
So once Mr. Tiller arrived at 2:03, what happens next with him until you sign your note at 2:39?
So I would not be able to determine that based on his medical record, since the event log says he got there at 7:22.
And are you talking about the documentation other than the triage summary, which provides the visit information?
Correct. There are multiple areas in this chart that have documented times. So I don't know whether 2:03 was the time the patient actually got there by looking at the chart, or did the patient arrive at 7:22 a.m. based on another portion of the chart.
And
So
what we do know is you signed your note at 2:39.
according to the medical record, yes.
And this medical record, you would admit, is inconsistent with itself.
I would say those times are confusing.
They're not just confusing, they're entirely inconsistent, true?
I don't know how to answer that question. I don't know how you're using the word entirely there, if I'm honest. So
Okay. 7 is not the same as 2, correct?
I would agree that 7 is often different from 2. So,
Is it ever the same as 2?
probably not.
All right. Okay, what did you document as Mr. Tiller's history?
His history, which history are you talking about? His history of present illness, his family history, his review of systems.
You tell me, walk me
So-
through this note, and you tell me what are the first 2 lines under emergency department visit note?
Sure. So this is a 60-year-old male complaining of chest pain / SOB / nausea / heartburn, altered sensorium, no significant medical history, no family history, no numbness. There is plus jaw pain, chest pain. Patient is very shaky.
Was the pain central?
It doesn't appear to be documented here, so I'm not certain.
Was it pressure?
It's not documented here, so I'm not certain.
Was it squeezing?
Not documented here.
So you don't know.
Nope.
Was it gripping?
Not documented here.
You don't know, correct?
Correct.
Was it heavy?
It doesn't appear to be documented here.
Was it tight, exertional, or retrosternal?
I have no knowledge of that.
Fair to state that you did not document the nature and the character of his chest pain.
Not according to this.
Fair to state that you do not know what the character and nature of his chest pain was.
It's not documented here, but my usual custom and practice would be to be aware of that and have a conversation with the patient. So
Sure. And you
obviously
would
I can't
usually
document every
document
word.
that.
Often, but not always. So it depends on lots of external factors.
And you know, don't you, doctor, that the standard of care, that is what a reasonable and prudent physician would do, is to determine in a 60-year-old man complaining of chest pain, the nature and character of that pain. True?
It can be, but may not be the most important part. And I'm not certain how to answer that question in the context of standard of care.
I'll help you. Standard of care is what a reasonable, prudent physician would do under like or similar circumstances. You would agree that the standard of care requires an emergency room physician to determine in this patient coming in at age 60 complaining of chest pain to determine the nature and character of that pain. True?
I would say that that could be part of the evaluation. So, but I would not stop my evaluation there. So, he could have chest pain that was not characteristic of some of the things you were describing, and I would still be obligated to perform a workup for ischemia.
And I think that what we're doing is we're having a disconnect. I just simply want to know if the standard of care requires you in this patient to simply determine by way of history the nature and character of the pain.
I would disagree with that.
Very good. Okay, he's stopping us. Anybody feel nervous?
I was having fun.
So just a couple of clarifications. I didn't mention it before we started. We didn't give you the medical record because it doesn't really matter
You did great.
to understanding the process. This was, how many in the audience are residents or junior faculty? Okay. So this was what we would call in olden times. This was back when we would request medical records and someone would push them on a card in manila envelopes, right? So the issue with that is that, you know, they can't find the ECG because it just wasn't copied. It was lost. It was physically lost. And in the less olden times, we were starting to get medical or electronic medical records where we was writing notes. We were still like having all the back information like that. So there were issues with the time stamping of the doc wrote the note later and it was time stamped different than obviously the troponins were done. You know, they weren't done magically when the patient wasn't there. But what questions do you have after having watched that, or thoughts do you have?
My understanding is that in the court, we are judged by what a reasonable person would do under similar circumstances. But in the ED, sometimes we have shifts where nothing's going on. Sometimes we have shifts where so much is going on. So while, like, of course, like I am going to ask about chest pain and the characterization of it and whatever, maybe it doesn't even matter because I'm going to get an EKG and tropes anyway. And maybe I asked about all these other questions instead, like the aortic dissection questions or other things that could lead to chest pain. And maybe there's a patient next door who decided to crash and a patient across the hallway who also needs to be intubated. So do you take that into consideration, like the shift and the context and how busy it was and what a reasonable person would do in that specific context?
So the last thing that a jury wants to hear is that you're too busy to do your job, right? So you are correct. You are held to what a reasonable and prudent physician would do under like or similar circumstances, but someone like me would take that and say, you're too busy to do your job. What did you do to get help? What did you do to notify someone that you needed help to tube somebody across the hall or to do something further? So if you really, and I get it, it's busy, but if you are too busy, my admonition would be tell somebody and get some extra help. But what Dr. Baker did incredibly well was to answer questions by way of custom and routine and to say, of course, I'm going to ask those questions. And if those questions had yielded XYZ response, then by custom and routine, I would have done STUV. You know what I mean? Like, so you can easily rely on custom and practice and say, of course I would have asked nature and character questions. And based on the way that I do things and how I document, those questions did not raise my indicia of suspicion too, or they did raise my indicia of suspicion and I did. But you want to stay away from busy. And if you do find yourself in that circumstance, you want to let somebody know, because busy can be a very big problem in these cases. And that's not to diminish what you do day in and day out, but it's to sort of give you the reality of how that word can be twisted in a way that's not friendly.
I guess in terms of like, obviously we would want to protect ourselves from litigation, and ideally in these situations would like to win. What tips would you offer in terms of like answering questions on the stand? I felt like Dr. Baker answered things more vague, or I do not recall. Do you find that like helps you more? And then also like within the documentation, is it better to be more like explain more the nature and character of the chest pain, or to leave things more vague in terms of like protecting yourself from legal risk?
Okay, so there's no black or white answer, but I'm going to start with the great news. The great news is that when these cases go to trial, 9 out of 10 times the defense wins. I defended this case. We won this case in Lake County, Ohio. Jurors know that you do your best, that you are busy, that you get up every morning to help people. It's what the rest of us don't do. And you do it for us. You start out with that edge. And if you are nice and compassionate on the stand and talk to those jurors directly and explain your thought processes, 9 out of 10 times you win. But I will tell you, most cases don't go to trial because oftentimes for there to be a lawsuit, there is an issue. In Ohio, we can't just go file a lawsuit. We need a medical expert to review the case and make a determination as to whether or not there's a reasonable basis to proceed. And your expert isn't, some guy on the corner. I mean, our experts have great credentials, and there typically is an issue. Most of the time, it's a system issue. It's not a you issue. It's more of a system issue. And you hope that these lawsuits, that we're all on the same page about patient advocacy, and that the risk management folks are fixing those system issues. I don't know if you've heard about the Swiss cheese model, but that plays in a courtroom because sometimes those pieces of cheese aren't lined the right way. But don't practice defensive medicine is my advice. Document the way that you would typically document, because you want to be you when you answer questions. You want to be able to talk about what you typically do, because the likelihood is, unless it's a complete awful mess, you're not going to remember the case. So you will be so well prepared by Denise for your deposition, and you will be prepared differently for trial, because it's two different conversations. One, you're getting cross-examined by me. The other, you're talking to a jury and explaining, right? And jurors love to hear you talk. So you will have ample preparation. I would change nothing about what you typically do, unless hearing this you go, uh-oh, I really need to make a change. Just be your authentic self, because that is what you want to be in a courtroom.
Right. And to follow up on that, they do want to like you. They do want to believe you. And if you guys are there to teach the jury and explain the circumstances, you'll have experts as well who will explain the medicine as well, and or why what you did was perfectly acceptable. So you just want to be the teacher and come across as exactly what she said. I went there to help somebody, and I was trying to help. I did everything. And when he's vague to the extent he said, I can't tell from here. If it's not documented and you don't have an independent recollection, the last thing you want to do is make something up and say 4 years, because it could be even longer. It could be 6 years. And you could be sitting there, and is a jury going to believe that you remember that this guy was sweaty or not sweaty? I mean, but as he explains, I document what is pertinent in my analysis. Just because it doesn't describe it doesn't mean I didn't talk about it.
And you don't get to hear his direct examination. This is just cross-examination by me. The direct, Denise would stand up and say, Doctor, you were just asked on cross-examination about nature and character of chest pain, and you said not necessarily, or whatever the answer is. Can you explain that? And then you have the opportunity to explain. This process is simply cross-examination for a deposition. It's not the opportunity for you to tell your story in front of a jury.
And there are very limited circumstances that I can intervene. When she started to go into the legal side of it, I can object. He doesn't have the foundation on a legal argument. I can object and prevent her from asking a question if it invades our privacy and discussions. But our preparation and preparedness happens before the deposition. Okay, I'm not getting in any fist fights in the middle of a deposition with anybody, and the court will fillet me if I object to every question just because I don't like it or I would rather it not be. But I also had great faith that Jeff could handle it. You know, we spent very specific time addressing some of the very issues that were discussed, and I knew he had it. But, you know, you can't anticipate everything, so you all have to believe in yourselves and trust your education, training, and experience. Marilina's the aberration. Most plaintiff's attorneys don't have a significant medical background. They've got just enough to try to be dangerous, or they have planted questions from their expert. They don't necessarily understand anything. So you all have to believe in yourselves and trust that you understand the whole situation. You have the medical background, and you guys are the experts at your deposition. None of the rest of us are.
There's a. Right in the back, Mike.
I'll make it.
Was it bad when I answered you asked, I spent more time reviewing the medical record than caring for the patient? So
It's
I
not my
regret,
favorite
I
answer.
regret answering
Right,
it that
it's
way.
not her favorite answer.
Yeah.
Yeah,
so-
yeah. It is what it is. It really is what it is. Most people don't see that question coming, right? And everyone wants to be prepared for their deposition. I'll twist that in the courtroom, right? But you have to remember, jurors know where your hearts are. They really do. And if there's not a real issue in the case, first in Ohio it wouldn't get filed, but you are likely going to prevail at trial. If there is a real issue, it will likely resolve, but you want to do your very best at deposition. You really do, and you did a great job. I mean, that's one answer. I mean, big deal, but you did a great job. Your demeanor was lovely. Your pace was lovely. Asking me to restate the question was great. I mean, you were a great example of what to do right in a deposition.
I also thought you did a great job. I noticed that you asked him about the nurse's triage note.
Yes.
If we're ever in this situation, which hopefully we aren't, but if we are,
So I'm sorry. I
Oh,
think
yeah.
I need hearing aids. You're gonna go. I hate to admit how old I am.
no, sorry, I'll be louder. What part of the medical record are we expected to review and then answer questions on beyond our own note?
This is a very timely question. I'm going through a case right now where each and every one of the witnesses has only looked at what he or she authored. And I think it's terrible for the defense. I think it's terrible because that's not how you practice, right? You're going to review something. You might review a vital, you might review a consult note. You're going to review something else in the chart. Remember, jurors want to root for you, but they don't want to believe that you operated in a vacuum and only charted what you charted to the exclusion of anything else. So the answer is the truth. Whatever you typically look at, typically look at. What you don't typically look at, you don't have to. I can't say it enough. Being authentic is what's most important. As you're taking your history, do you typically look at what the triage note says, or do you not? Whatever it is that you typically do, I would do. But I do think jurors want to hear that you reviewed something other than just what you yourself authored.
And you cannot verify, you weren't there, you have this record. And that's why on occasion he said, well, that's what it says. He wasn't there. And so you do read it, I suspect, and you have all wealth of information from many sources. But at this point, at the end of the case, when you're sitting there to get deposed, you'll have the entire record. And it's not going to be 8 pages, right? And there's going to be, of course, I'm talking old school charts with Mike here. You know, you had tabs for all the labs. You had, tabs for the progress notes. You had tabs for the nurses' notes. You had, it was this thick. You guys don't have to necessarily deal with that at this point, and you can be a little more laser focused at what you look at. But again, don't be afraid to look at the information, but you, again, can't independently verify its accuracy.
One important thing, please be careful of the cut and paste. Don't cut and paste inaccurate information and look at that. But that's a system problem, I think. But folks cut and paste and don't read what they're cutting and pasting, but now you're responsible for it. So if you've cut and paste something that's inaccurate into your own note, now it's your note. If you've cut and paste something that has CT scan findings that identify a mass in the right upper quadrant and you put it in your note and nobody ever follows up on the mass and the person dies of stage 4 lung cancer, that's just as much your problem as the person who interpreted the scan. So be careful with the cut and paste.
And EMRs are good and you have drop down menus, but that doesn't mean every box gets checked. They ordered a pregnancy test on this gentleman based on the record. So you just have to make sure that you're not drawing in or letting other, check boxes that you're not supposed to and are clearly not applicable.
First, let me say I learned a lot from listening to that, and I appreciate it. My question is this. It seemed to me that the questioning was almost accelerating. If he gave a direct answer, yes or no, you were into your next question very quickly. And that has the potential for the person being examined to get a little bit confused or to trip over their answers. Is there a way for the person being deposed to sort of pace the questioning or their answers? Is there a good technique for that?
Denise was tapping on my chair, but I was ignoring her. So, I don't know if that was intentional. So, yeah. So.
No, but you can ask them to repeat the question. If you're concerned about it, you should always, and then one of the first things I'll say is, they ask a question, take a beat, because I may need to object. Chances are good I can object, but I may need to. Or I may want to throw off her case. But as a general rule, unless the question is patently unfair or inaccurate, or there's some objection to it, a yes or no answer is not a bad thing. Every time you give a long answer, there's 10 more questions coming. Okay, so if it's clear cut or it's not in here, is it? You don't fight on that stuff because the jury won't like it, and it doesn't. You're not going to win your case in deposition most of the time. You can do, no harm. You can try not to get exasperated with them and mad and react. And most of the time, you'll probably be on videotape, and they are free to show that video to a jury. And they don't have to wait for you to get up there and be calm, cool, and collected. You lose it in deposition, it's probably going to be on video.
Hi, thank you so much for this experience. I have a twofold question. The first, I don't know if this is coming from my own fear from this experience, but if the reassurance is that in front of a jury, you can explain yourself and go through the process more, what is the goal of the deposition? Is it meant to trip you up by asking questions in these potentially confusing ways or stressful ways, or what is the goal of that? And secondly, can you comment at all on an inherent nature of our job, which is sign-out culture, where we do often have to transfer care from one physician to another?
So I'll address the first question. Both sides, I, on behalf of the patient, take the physicians or nurses or others involved in the care, and Denise takes the patient. The very first reason for doing that on either side is to assess the witness. Is this a believable, credible witness? What information, if any, does this witness have that's not included in the medical record? And how can this witness explain what has transpired or what's not in the record? What is this witness's fund of medical knowledge? Will the witness acknowledge tenets of medicine that I believe weren't followed in the case? And if you can get those acknowledgments, that's better for my case. If Denise can find a non-compliant patient or a malingerer or something that helps her case, then she's found it. Why are we even looking for these things? Well, as I said, for the case to get to trial, for the case to get to a courtroom, to be filed, there has to be merit to it identified by a non-involved physician. Now, for Denise and for me, it becomes an issue of risk. Where is the risk greater? Where is the risk less? If he is a good witness, the risk for Denise is less. If he is a bad witness, the risk for Denise is higher. Same for my clients. And the process of a lawsuit is an assessment of risk to see where those risks intersect that the case can resolve. Now, sometimes in a jurisdiction where you don't need an expert, or perhaps where there's just been a misassessment, you never get to those risks intersecting and the case being resolved, and you go to trial. And at trial, there can be no trial by ambush. You have to know all of the evidence going in a civil case. So I want to know all of the evidence that Dr. Baker and others might have that's not contained in the record, and Denise wants to know the same about my clients. To your question about sign out, yes, tell me more specifically your concern.
So very often we're on either end of the spectrum where we are either the first physician to see the patient, and therefore a lot of the medical decision making has been established by us up front. But if by a miracle we get to go home, now another physician has taken over that responsibility for the decisions that we made. And of course they can change things as they see fit, but there is a degree of bias that comes into that because they're coming with someone presented to them. So from both angles, I can see there being a twist in that, where if you were the first physician who then left, is it really your responsibility when you haven't been able to see the case through? And then on the receiving end of that, if you are the one who is receiving that patient and responsible for carrying out the remainder of their care, you are receiving a half-wrapped package, so to speak.
Yep.
And one other thing with regard to the discovery, from my perspective as the defense counsel, I will want, in this case, we can't take Mr. Tiller's deposition because he passed. What was it, the day after?
The same, when he went home.
Same night. But she's got a good story on that too. But the issue, I would want to speak to the wife. Was she present? If she was present, did she participate in any conversations with the doctor, the staff, or anybody? Because the last thing I want in the middle of trial is to have the widow get up there and say, well, we talked to this doctor and he said A, B, and C. And if that's the first time we're hearing about that, that you're acting on the fly. And so I would ask and give them every opportunity. Did you speak to anybody else? Did you at any time have any interaction with this person or that person? And if she's not there, then that's a very short part of the deposition. But you want to know that from the fact witness, the widow, if any family's there. In different situations, you could have a longer stay. You could have more people in and out. But you want to know before trial.
And I think on, signing out, I really honestly have not had a case that dealt with the issue of a new physician coming on, other than an anesthesia case that had to do with the epidural following a cesarean section delivery. I think it would be difficult from a plaintiff perspective to make the initial physician responsible for the subsequent conduct, or the subsequent physician responsible for the initial conduct. I think it really is what a reasonable, prudent physician would do under like or similar circumstances. So you'd be limited to you regardless of where you fall in that chronology, and same for the person taking over. The OB case, I was trying to think of an example. The OB case that I was thinking of was one in which it had been, I don't know how many hours. So I forget if they were working 12s or 24s, but where the patient had not moved her lower extremities, and it, put the oncoming anesthesiologist in a spot. I was actually representing him. That's the only case I can think of where that happened on a transfer of care, and he was a bit surprised at the patient's clinical status.
Just trying to read the room on that a little bit. Is it useful to document if I'm the outgoing physician, I turned over the care of this patient to Dr. So-and-so,
Yes.
and if I'm the oncoming physician, I resume care of
Yes.
this patient from Dr.
1
So-and-so.
million
Would that
percent.
would be the
That
right
would
thing
be,
to do?
yes.
So-
And in fact, one of the other things I was thinking, most ER records that I've looked at recently, there is on the electronic medical record, so-and-so signed as attending, so-and-so now assigned as attending and removed as attending. It's pretty clear in most electronic medical record keeping systems who's in charge when. But if it's not, that's a great point. Make it clear.
Yeah, typically electronically it is, but it's not great of a hardware culture that we are documenting when we take orders. The electronics will reflect that, but a lot of people will follow whatever plan is outlined and then act on it without necessarily done. For better or worse.
I would document assumed care of patient at X whatever time. But I don't want to impact the way you deliver patient care either. The nurse, whoever's doing it for you, I mean, it's pretty clear in that ED flow record who's taking care of who when.
Hi. There are certain rare but high risk diagnoses that I think it's challenging to document around. The one that comes to mind for chest pain is aortic dissection. It's not practical to get a CT to rule out dissection for every patient that comes in with chest pain. And you'd have to have some sort of index of suspicion, I think, to go down that path. And I've gotten very mixed feedback about how to document that in my note. If you don't have an index of suspicion, not comment on the dissection at all? Do you say, I'm just not concerned? Do you say it's low risk? Because I think each approach I have heard concerns with, and I'm just not sure what your perspective is on to how to document or not document things that we're not that worried about and therefore not chasing, but theoretically could still be going on with the patient.
Mike actually has a great way to document that. Mike, do your documentation.
What's your opinion, Baker? I'll give you mine.
I document my medical decision making. I have a low suspicion of this disease. It can't be completely excluded sometimes. So that's my off the cuff answer.
So my notes, I usually, before they would force us to put differential diagnoses in as part of billing, I wouldn't put an exhaustive differential diagnosis. It doesn't matter if you considered a subarachnoid hemorrhage. If you didn't find it and you sent them home, they died from it. If that makes sense. So if you see like sort of the nurse practitioner notes, like where they're like 20 pages long, you need a table of contents and stuff that I don't write a note like that.
What's your phrase that you use?
So that's a little bit different thing. Like, so like for like things like chest pain, like I would say I would tend to err on towards the side of I'd probably send more patients home than average, but I usually involve the patient with that. So I review like, look, this is what we've got. It's negative. I can't put you at zero risk. This is what we could do if you're really nervous. I could put you in for observation. If you wanted to go home and follow up, that would be medically appropriate too. So I document that I discussed it with the patient. We arrived at a shared decision about what to do, and that's the way I do it. I think the biggest
I think your
thing.
use of low suspicion is a good way to go.
Yeah, you're gonna come out of rooms and you're gonna be like, that was really dicey. Like I'm probably gonna be getting a letter in several months, right? And you're not gonna get a letter. And then when you get the letter, it's gonna be a surprise. So there was a saying that a doc used to say is, I've committed malpractice, I've been sued, I've just never been sued for malpractice.
It's never the ones you think it's going to be. I guarantee it.
I didn't think it was the Percocet lady. I didn't think it was gonna-
I practiced in Louisiana for a long time, so there's a low bar to file suit there, and I'm not ashamed to say I think I've lost track of the number of times I've been named in a suit in Louisiana. So I don't think it's 10. So and but there's medical review panels, all that kind of nonsense. So which is a good thing. So I've never gone to court for any of these, but so it's never the ones I thought it was going to be. So in fact, some of the ones I've been sued on, I was like, I'm a good doctor. That's amazing. So, geez.
One of the things I would sort of harp on in teaching the Sim Center is, and she's trying to trap him in this as well, as she's trapping him on risk factors, right? So risk factors, just like the Center, you're likely what's going to contribute that this may happen to you. It's not your diagnosis, right? So you may have every risk factor under the sun for having acute coronary syndrome. If someone punches you in the chest, you're not having acute coronary syndrome, right? Likewise, the flip side, if you're 19 years old with no risk factors, you come in with crushing chest pain, you do an ECG and they've got inferior ST elevation, what's your diagnosis? They're having MI, right? So, but they have no risk factors. It doesn't matter, right? And I've had attending cardiologists ask me, what are his risk factors? I'm like, the fact that he has heart disease and he's having a heart attack. Like, does he smoke? I was like, I didn't ask him. I thought it'd be kind of cruel. Although I guess it's a teachable moment. Like, we don't think you should smoke. But that's, and we covered the sort of the, what you'll hear from every nurse. If it wasn't documented, it wasn't done. And that's not realistic, right? Like I said, you're going to walk out of something that's really dicey and you're going to write a novella with a table of contents. And that's probably not what you're going to end up being sued over. But my notes are probably on the short side compared to other emergency physicians.
Mine are bare bones these days, but I will say, just because I know we're running out of time here, if you're like in an educational setting, so you can do this at your own program. So I took Mike's sort of platform and just basically talked to our lawyers, and we put one of our senior residents in this seat, so who really didn't prepare, and it was enlightening for everyone. And this reminded me that we need to do this again. So at my shop, so it's something that you can do at your own residency if you want
Please
to.
know
So-
that your perfect serves, doc halos, text messages, communications among care providers are all discoverable. We will see them all.
And
Don't text.
Please.
So when you communicate about a patient, treat it as though someone's going to be reading it.
And please never argue in the chart. Don't make some passive aggressive statement about a consultant. I mean, if you really want to fight with them, like go out in the ambulance bay and like punch each other in the face, which I can admit, like we used to do in the olden times,
Good old days, wild, wild
occasionally
west.
with trauma surgeons at Metro Health in Cleveland, hypothetically. But don't argue in the chart. It's just fuel for them. They're like licking their lips reading that you said, like, Dr. Jones didn't respond or said that this wasn't a STEMI or something like that. Any other last minute?
Oh, you have someone right back there.
If there's time for one last question.
Sure.
How do you consider the role of resident documentation versus attending documentation, or any discrepancies in that when something goes too soon?
When your attending does the attestation, it's up to the attending to accept or edit your note. So it is ultimately at the hands of the attending.
If the attendee goes in and deletes things or modifies things that a resident previously brought up and used on board.
So can you do that without it showing up that it's been deleted or modified?
But is that
It's still the attending's call. I'm used to being able to see what that modification has been. So really, at the end of the day, the resident can always say, I'm a resident in training, and the attending is the attending, and that is the way it is. You know, at certain institutions, state institutions in Ohio, we can't even sue the resident. The resident has no liability at Ohio State University because it is the attending whose job it is to monitor that resident. Other places it's different, but I guess what I'm saying is, as long as you are a resident, you are still considered resident in training.
So for attendings that are working with residents, they should acknowledge what the resident writes and say, despite what the resident wrote?
Depends on the some institutions have. Does yours have that attestation form at the bottom, and then where you freehand type? Then I would freehand type what you disagree with, right? Or agree with it. But if you disagree, I wouldn't just say I disagree. I would say I've done my own independent examination and I find that blah blah blah, whatever the difference is.
And then do that 50 times on a night shift. So
I edit their notes.
You mean you just go in and
I edit their notes and correct, and I talk to the resident, tell them yeah. Oh, they're gonna get there's a talk involved too, you know, like if there's something really goofy. Next.
all right.